This case starts with a shocking contradiction. A defendant on probation, 7 months pregnant, and still caught up in drug possession. What unfolds in this courtroom isn't just about breaking the law. It's about choices, consequences, and a judge who refuses to ignore the bigger picture. As the tension builds, you'll see how quickly a second chance can slip away. But here's the real question. When someone risks not just their future, but their child's, how far should the court go? Stay with us, because this hearing takes a turn that no one in that courtroom could ignore.
2024 CR 4982, State versus Briella Butler. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Patrick Collins for the defense.
And are you Ms. Butler?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Briella Butler who's placed on deferred adjudication in 2024 CR 4982 for the offense of forgery of a financial instrument on February 12th, 2025 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violating condition number one, on or about the 22nd day of May 2025 in Bexar County, Texas, the defendant, Briella Butler, committed the offense of possession of a controlled substance, plea group 1, in violation of condition number 1.
How do you plead to that, true or not true?
True.
I'm sorry, was that true?
True.
Thanks, ma'am. We'll waive the remaining violated condition, Your Honor.
Yes, no, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
No, Your Honor, it's unagreed.
All right, state, what are you requesting?
The state is requesting adjudication of guilt and revoke for community supervision for 18 months in the state jail facility. One part of the agreement, we are taking into consideration the possession case she just pled to, which is JN 7143967. And we're also taking into considerations a county court at 2 case 2025 CC 011626, which is a failure to ID.
All right, in defense, what are you requesting? Oh, you can't sign it.
Well, this is the
This is, okay.
Your Honor, we're requesting that you continue her on probation, to deny the motion, and to follow the recommendation by probation to send her into the MIC unit or some other type of supervisory program with zero tolerance.
I really don't normally do zero tolerance in this court because being on probation, you're supposed to follow the rules. So my question for you, or maybe for her, what have you done? Because you've been on probation since February. What have you done? Have you completed? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Briella Butler.
What have you done?
I went to the 60 days NA or AA online virtual visits. I reported twice.
All right, so that didn't work because you're here for a possession of controlled substance. What was that controlled substance?
Methamphetamines.
All right. So we know that doing the 60 days didn't work because you have a possession of meth. And how far along are you in your pregnancy?
7 months.
All right. So what that means is you're doing drugs.
No, ma'am, I wasn't.
Who did the meth belong to?
DeAndre Hartley. I have an affidavit that they brought in.
This is the moment where everything changes and the judge zeroes in on the core issue. The admission of meth possession alone is serious, but layered with a 7-month pregnancy, it raises the stakes dramatically. Legally, the court is now balancing rehabilitation versus punishment, but emotionally, this hits much harder. Notice how the judge immediately connects the dots. Probation was already a second chance, and now there's a clear violation. The defense tries to shift blame to another individual. But in situations like this, possession, and responsibility often outweigh excuses. So ask yourself, should the court focus on giving her another chance? Or is this exactly where accountability has to take priority?
It wasn't mine. I did stay at the scene when the cops came. My car, I just bought it, it was broke down, and I was at my mom's house, and cops pulled up, and when they pulled up, my friend ran off, and they immediately put me in handcuffs and searched the car.
So let me just tell you right now,
And
the only way you're going to be continued on probation if you go into inpatient treatment. We're not doing this zero tolerance thing. So she can either go into inpatient treatment, and because you're pregnant, they will accept you at safety. But they're not going to accept you at any of the programs because of how far along you are in your pregnancy. So you can either do that or you can do the 18 months.
okay. Thank you. Can I take my baby with me?
No, what ends up happening when you are at safety, because it's at the prison, when you're at safety and you deliver your baby, someone needs to be there to accept custody of your child. Otherwise, Child Protective Services will be picking up your baby and you will have a CPS case. And when you're released from safety, that's what will happen. You will have to do parenting classes and everything else that's required of you. And when you have somebody, if you have your mom or whoever it is to come pick up your child at the prison, they will make a determination on whether or not that person is appropriate or not. All right. So the court will deny the motion. Alter and amend conditions to include safety. Probation, is there anything you recommend other than safety? I'm sorry, what? All right, so there'll be safety, and that's, of course, is in custody. And then it is 9 months. And you have to wait. What's the wait time for safety? I'm sorry, what? All right, so usually the wait time for safety normally is 3 months. So you'll be waiting at the jail for 3 months, then they'll transfer you to safety and you'll be there for 9 months. All right, so the court is going to deny the motion, alter and amend conditions to include safety. Once she is released from safety, she's to be placed on the MIC caseload, and there's to be no unsupervised contact with minors, field visits until further notice. She's to complete parenting classes. Court will take in consideration JN 7143967 and 2025 CC 011626. All right. Is there anything else?
Nothing from us, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, the court is calling 2025 CR 010368 State versus Devin Grisham. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Christopher Simpkins for the defense.
And are you Mr. Grisham?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Grisham, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the
We
indictment?
do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor, I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
My opinion is.
Mr. Grisham, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied re-entry, and denied naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor, I did.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They're taking in consideration 2025 CR 011698. There's to be restitution to Quick Trip, QUIK Trip, and also to Walmart. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such
There
motions?
have been none.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours community service restitution, and no contact with Quick Trip or Walmart. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. State Exhibit number 1 with office attachment.
No objection, Your Honor.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we've asked to follow the plea bargain agreement. Mr. Gone over the matter of Mr. Grisham. He is motivated to be successful. I would also ask the court to consider probating some of the community service hours if he obtains a GED and employment.
All right. Mr. Grisham,
Yes, ma'am.
it appears that you have a problem with taking things that do not belong to you. Why do you keep stealing?
I had a drug habit, ma'am, so it was kind of related to that. Before being incarcerated, I just actually quit doing drugs.
All right, what drugs were you using?
I'm methamphetamine son
How often were you using?
every day.
Okay. All right. Thank you for being honest with me.
Yes, ma'am.
Do you have any children?
No, ma'am.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's a $2,000 fine that will be probated. In custody, the following. There's a referral to felony drug court. You need to be honest with them. That's a great program. They can really help you.
Yes, ma'am.
And there's to be a TAP evaluation in custody. If not accepted in felony drug court, Then follow TAP recommendations. There's to be proof of employment within 45 days, no employment as a home health care provider or with minors. There's to be restitution to and no contact with Quick Trip or Walmart.
May I ask a question, ma'am?
Yes,
Is that like just that Walmart or is that like in the
they
nation?
don't want you there.
Okay, so in the.
Now, I will tell you, I will reconsider that once you've been clean and sober. You understand?
Yes, ma'am.
All right, there's to be regular reporting by Zoom or in person, regular random UAs, field visits one time per month until further notice, no residing in households with minors, and there should be no unsupervised contact with minors. And take in consideration 2025 CR 011698. State, is there any, I'm sorry, probation, is there anything else? Is there anything else you need from the court in order to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. So here's the thing. In order to be successful, you need to communicate. If there's an issue and you feel like probation is not addressing it, you can always come back to me.
Yes, ma'am.
When you're accepted in felony drug court, and I know you'll be accepted if you are honest with them, what will end up happening is they will be in charge of your conditions. So the conditions that I've given you, those are for when you're in this court. But if you're accepted in a felony drug court, they may have different conditions that may be different from mine. They may say, no, we don't need to do field visits. That will be completely up to them.
This case is a powerful example of how quickly circumstances can escalate when probation conditions are violated, especially when drug use is involved. The judge's ruling reflects a firm stance. Rehabilitation is still possible, but it comes with strict structure and serious consequences. Instead of immediate prison time, the court mandates a long-term inpatient treatment program, emphasizing accountability while still offering a path forward. But the emotional weight of this case is undeniable, particularly with the involvement of an unborn child and the potential for CPS intervention. Ultimately, this wasn't just about punishment. It was about forcing a turning point. Now we want to hear from you. Do you think the judge made the right call? Or should there have been more leniency given the circumstances? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.